Welcome back to our channel. Now we are discussing on NCLAT ruling, section 9 application under IBC, inadmissible for defaults during section 10A Moratorium, COVID-19 period. The National Company Law Appellate Tribunal Principal Bench New Delhi has clarified that section 9 application under the Insolvency and Bankruptcy Code 2016 is not maintainable when the alleged default arises during the section 10A moratorium period. Further, if recalculated by excluding such prohibited defaults and the claim falls below 1 crore statutory threshold, the application becomes inadmissible. The Appellate Tribunal also underscored that the continuing the corporate insolvency resolution process after a full settlement is misuse of the IBC framework, which is designed for resolution of insolvency and not for debt recovery. You'll see the background of the case. The corporate debtor, Chandrima Fashion Fabrics Private Limited, and operational debtor, Srinivasa Cloth Mills. The dispute arose from supply of fabrics materials by Srinivasa Cloth Mills between April and October 2019, for which the payments were not made. A demand notice under Section 8 of IBC was issued on 25th November 2019, followed by settlement deed 31 January 2020, wherein the corporate debtor agreed to pay 1.114 crore. While partial payments were made, further default led the operational debtor to issue another demand notice on 19th June 2020 and file a Section 9 application before NCLAT Calcutta Bench 2 on 17th November 2020, seeking for admission of CIRP. So here the key issues before NCLAT, whether the defaults during Section 10A moratorium period, that is 25th March 2020 to 28th February 2022, can form the basis for Section 9 application. Another question, whether calculated a debt falling below 1 crore threshold after excluding prohibited defaults makes the application non-maintainable. Third question, whether CIRP can be continued despite full settlement of dues. So the tribunal findings, Section 10A bar, except for one installment due on 28th February 2020, all other installments under the settlement fell within the prohibited period. So thus the default during the period could not be considered because of the Section 10A bar. And come to the threshold limit, upon recalculation, the outstanding amount fell below 1 crore, making the application inadmissible under Section 9. And full settlement ignored actually, despite receiving all the full settlement amount by 17th July 2024. The operation debtor refused to file Form FA from withdrawal, which the tribunal held as abuse of the process. And misuse of IBC, the bench observed that IBC cannot be used as a debt recovery mechanism. And they condemned the creditors' insistence on pursuing CIRP after complete payment. So the final order was the NCLT order dated 24 April 2023, admitting the Section 9 application was set aside. The CIRP against the corporate debtor was terminated. 1 lakh cost imposed on the operational debtor payable within 30 days. Here the significance reinforces the predictive intent of the Section 10A, safeguarding the business from insolvency during COVID-19 period, and clarifies the threshold application. Recalculated debt below 1 crore makes Section 9 application non-maintainable. Strengthens jurisprudence against the misuse of IBC. So we have two channels, RR Corporates and RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss any of our latest updates. Thank you.